Officers for the state at large.
Section 84. When Lieutenant Governor to act as Governor, President of the Senate not to preside at impeachment of Governor, certification of disability of Governor. Should the Governor be impeached and removed from office, die, refuse to qualify, resign, certify by entry on his journal that he is unable to discharge the duties of his office, or be, from any cause, unable to discharge the duties of his office, the Lieutenant Governor shall exercise all the power and authority appertaining to the office of Governor until another be duly elected and qualified, or the Governor shall be able to discharge the duties of his office. On the trial of the Governor, the President of the Senate shall not preside over the proceedings, but the Chief Justice of the Supreme Court shall preside during the trial. If the Governor, due to physical or mental incapacitation, is unable to discharge the duties of his office, the Attorney General may petition the Supreme Court to have the Governor declared disabled. If the Supreme Court determines in a unanimous decision that the Governor is unable to discharge the duties of his office, the Chief Justice shall certify such disability to the Secretary of State, who shall enter same on the journal of the acts of the Governor, and the Lieutenant Governor shall assume the duties of the Governor, and shall act as Governor until the Supreme Court determines that the disability of the Governor has ceased to exist. Before the Governor resumes his duties, the finding of the court that the disability has ceased shall be certified by the Chief Justice to the Secretary of State, who shall enter such finding on the journal of the acts of the Governor. Voters approved an amendment to this section in 1992 as a part of an omnibus reform of the executive branch. This section specifies the occasions when the Lieutenant Governor must exercise the duties of the office of Governor. The amendment deleted language in the original section that transferred the power of the office to the Lieutenant Governor when the Governor was absent from the state, a reality that occasionally produced great controversy. For example, in 1934, when Governor Ruby Laffoon absented himself from the state, Lieutenant Governor A.B. Happy Chandler, much to Laffoon's chagrin, called a special session of the General Assembly for the purpose of reinstating a compulsory primary law as a prelude to his successful campaign for the governorship. Because of his rivalry with Lieutenant Governor Harry Lee Waterfield, Governor Edward T. Breathitt was afraid to leave the state during his term of office, 1963 to 1967. The amendment also added a paragraph that provides a process for certifying the disability of the Governor and retains language designating the Chief Justice as the presiding officer in an impeachment trial of the Governor. There have been no published court decisions concerning this section. Section 85. President of Senate, Election Powers. A President of the Senate shall be elected by each Senate as soon after its organization as possible, and as often as there is a vacancy in the office of President, another President of the Senate shall be elected by the Senate, if in session. And if, during the vacancy of the office of Governor, the Lieutenant Governor shall be impeached and removed from office, refuse to qualify, resign, or die, the President of the Senate shall in like manner administer the government. Also part of an omnibus reform of the executive branch, a 1992 amendment to this section empowered the Senate to elect one of its own as president, an office formerly held by the Lieutenant Governor. In 3 previous constitutions and the original version of the current charter, the Senate elected a president pro tempore, designated as a speaker pro tempore in the 3 previous constitutions, to preside over the Senate should the Lieutenant Governor become Governor, or to become acting Governor should both the Governor and Lieutenant Governor be unable to serve. The first constitution designated the Speaker pro tempore of the Senate as the Governor's successor, as there was no Lieutenant Governor. Although the powers of the office are not delineated in the Constitution, the President of the Senate is by virtue of Senate rules and custom the most powerful member of that body. There are no published opinions about this section.
Section 86. Compensation of President of the Senate. The President of the Senate shall receive for his services the same compensation which shall, for the same period, be allowed the Speaker of the House of Representatives, and during the time he administers the government as Governor, he shall receive the same compensation which the Governor would have received had he been employed in the duties of his office. Part of the same omnibus reform of the executive, a 1992 amendment provides that, when acting as Governor, the President of the Senate shall be paid the same as the Speaker of the House or the Governor. There is no published adjudication of this section. Section 87. Who is to act as Governor in absence of Lieutenant Governor and President of the Senate? if the lieutenant governor shall be called upon to administer the government in place of the governor, and shall, while in such administration, resign, or die during the recess of the General Assembly, if there be no President of the Senate, it shall be the duty of the Attorney General, for the time being, to convene the Senate for the purpose of choosing a President. And until a President is chosen, the Attorney General shall administer the government. If there be no Attorney General to perform the duties devolved upon him by this section, then the Auditor, for the time being, shall convene the Senate for the purpose of choosing a President, and shall administer the government until a President is chosen. As a part of the 1992 Omnibus Reform of the Executive, an amendment to this section provided that if the Lieutenant Governor cannot serve in place of the Governor and there is no President of the Senate because that body is in recess, then the Attorney General must convene the Senate to elect a President to administer the government. In the meanwhile, the Attorney General is to run the government. If there is no Attorney General, then the Auditor is to carry out these responsibilities. Under this section as originally written in the current Constitution, the Secretary of State or, if that office was vacant, the Attorney General constituted the officers designated to carry out these responsibilities. There are no published decisions about this section.
Section 88. Signature of bills by governor, veto, passage over veto, partial veto. Every bill which shall have passed the two houses shall be presented to the governor. If he approve, he shall sign it. But if not, he shall return it, with his objections, to the house in which it originated, which shall enter the objections in full upon its journal, and proceed to reconsider it. If, after such reconsideration, a majority of all the members elected to that house shall agree to pass the bill, it shall be sent, with the objections, to the other house, by which it shall likewise be considered, and if approved by a majority of all the members elected to that house, it shall be law. But in such case the votes of both houses shall be determined by yeas and nays. And the names of the members voting for and against the bill shall be entered upon the journal of each house respectively. If any bill shall not be returned by the governor within 10 days, Sundays excepted, after it shall have been presented to him, it shall be a law in like manner as if he had signed it. Unless the General Assembly, by their adjournment, prevent its return, in which case it shall be a law, unless disapproved by him within 10 days after the adjournment, in which case his veto message shall be spread upon the register kept by the Secretary of State. The governor shall have the power to disapprove any part or parts of appropriation bills embracing distinct items, and the part or parts disapproved shall not become a law unless reconsidered and passed. As in case of a bill, the framers of the current Constitution empowered the governor to veto part or parts of appropriation bills because of the tradition of inserting questionable appropriations in otherwise sound legislation. Under the previous constitutions, if the General Assembly had adjourned before the 10-day period had expired, the governor could veto the bill during the first 3 days of the next legislative session. Under the current section, governors often waited until near the end of legislative sessions to veto, which did not allow time for legislators to override. An amendment to Section 42 in 1979 substantially remedied that problem by permitting the General Assembly to recess to allow the 10-day period to expire and then reconvene to consider the governor's vetoes. The Kentucky judiciary has invalidated a governor's veto that was unaccompanied by a message stating his reasons for the veto, from Arnett v. Meredith, 1938, and has held that a statute that authorizes the budget to be introduced into the General Assembly by joint resolution violates Sections 47 and 88, which require the budget to be introduced by a bill. In Legislative Research Commission v. Brown, 1984. Section 89. Concurrent orders and resolutions on same footing as bill. Every order, resolution or vote, in which the concurrence of both houses may be necessary, except on a question of adjournment, or as otherwise provided in this Constitution, shall be presented to the governor, and, before it shall take effect, be approved by him. Or, being disapproved, shall be repassed by a majority of the members elected to both houses, according to the rules and limitations prescribed in case of a bill. A similar provision appeared in each of the 3 previous constitutions, the initial language having been borrowed from the federal Constitution. The purpose of Section 89 is to prevent the General Assembly from evading the requirement of securing the governor's approval of bills by passing legislation in the form of resolutions or orders, sometimes called ordinances. The small amount of adjudication that has involved this section suggests that resolutions that do not resemble statutes do not require the governor's approval. Thus, a joint resolution authorizing a meeting of the Joint Assembly to elect penitentiary commissioners as provided by law, and the vote taken in such an election need not be presented to the governor for approval in Commissioners of Sinking Fund v. George, 1898. However, in the opinion of the Attorney General, Section 89 requires the governor to sign a joint resolution directing payment to ministers of churches who officiated at the opening of the daily sessions of the General Assembly.
Section 90. Contest of election for governor or lieutenant governor. Contested elections for governor and lieutenant governor shall be determined by both houses of the General Assembly, according to such regulations as may be established by law. The language in this section is the same as that used in the equivalent section in the Third Constitution. The most famous invocation of this section occurred in 1900, when it was used to determine the winner of the bitterly contested gubernatorial election of 1899. The State Canvassing Board certified the Republican candidates for governor and lieutenant governor, William S. Taylor and John Marshall, as the winners. The Democratic candidates, William Goebel and J.C.W. Beckham, filed a notice of contest with the democratically controlled General Assembly. According to the procedure of contest established by the General Assembly, a contest board was chosen from the members by lot, which heard evidence on the contest. The board, which was heavily dominated by Democrats, reported that Goebel and Beckham had been elected, and the full General Assembly, which was also heavily Democratic, endorsed this report and declared Goebel and Beckham the winners. 3 days before the decision of the legislature, someone shot Goebel, who died 1 day after being sworn into office. Taylor sued to prevent Beckham from succeeding Goebel as governor and to have himself declared to be duly elected. Taylor's lawyers argued that the Legislative Contest Board was not fairly drawn by lot and did not actually review the evidence and, moreover, that the entries in the legislative journals had been fraudulently composed to support the legislative decision. In affirming the legislative declaration of Goebel and Beckham's election, the Kentucky Court of Appeals held that neither Section 90 nor the procedure adopted by the General Assembly violated the 14th Amendment of the Federal Constitution, as the office of governor is not property and the determination of the result of an election is purely a political question into which the judiciary is powerless to inquire. From Taylor v. Beckham, 1900.
Section 91. Constitutional state officers, election, qualification, term of office, duties, Secretary of State to record acts of governor and report them to General Assembly. A treasurer, auditor of public accounts, commissioner of agriculture, labor and statistics, Secretary of State, and Attorney General shall be elected by the qualified voters of the state at the same time the governor and lieutenant governor are elected, for the term of 4 years. Each of whom shall be at least 30 years of age at the time of his election, and shall have been a resident citizen of the state at least 2 years next before his election. The duties of all these officers shall be such as may be prescribed by law, and the Secretary of State shall keep a fair register of and attest all the official acts of the governor, and shall, when required, lay the same and all papers, minutes and vouchers relative thereto before either house of the General Assembly. The officers named in this section shall enter upon the discharge of their duties the first Monday in January after their election, and shall hold their offices until their successors are elected and qualified. An omnibus reform amendment of the executive branch changed this section in 1992, by eliminating the elected office of Superintendent of Public Instruction and any mention of the Register of Land Office, which had been abolished in 1898 pursuant to Section 95. By including the Secretary of State in this section, the framers of the current Constitution made that office an elective one for the first time, and by including the Commissioner of Agriculture, Labor and Statistics, made that office constitutional and elective. It had been created as an appointive office by statute in 1876. The Kentucky Supreme Court held that, aside from informational duties, officers named in this section cannot be placed under the governor's control or supervision. Powers, duties, personnel, funds, or property that are given to an officer named in this section may be transferred by executive order only if such transfer is authorized by statute. From Brown v. Barkley, 1982. The Special Commission on Constitutional Review of 1987 recommended that the office of Secretary of State be abolished and consolidated with the office of Lieutenant Governor, and that the number of statewide officers to be elected be reduced to 4, the Governor, Lieutenant Governor, Attorney General and Auditor of Public Accounts. Section 92. Qualifications of Attorney General. The Attorney General shall have been a practicing lawyer 8 years before his election. The current Constitution is the first to provide qualifications for the Attorney General. During the election of 1995, an ally of the Republican nominee for Attorney General unsuccessfully challenged the candidacy of the Democratic candidate, Ben Chandler, on the grounds that Chandler, if elected, would not have been a practicing lawyer for 8 years. The Kentucky Court of Appeals affirmed a decision of the Franklin County Circuit that Chandler had satisfied the requirement of Section 92 in Staten v. Chandler, 1995.
Section 93. Succession of elected constitutional state officers, duties, inferior officers and members of boards and commissions. The Treasurer, Auditor of Public Accounts, Secretary of State, Commissioner of Agriculture, Labor and Statistics, and Attorney General shall be ineligible to re-election for the succeeding 4 years after the expiration of any second consecutive term for which they shall have been elected. The duties and responsibilities of these officers shall be prescribed by law, and all fees collected by any of said officers shall be covered into the Treasury. Inferior state officers and members of boards and commissions, not specifically provided for in this Constitution, may be appointed or elected, in such manner as may be prescribed by law, which may include a requirement of consent by the Senate, for a term not exceeding 4 years, and until their successors are appointed or elected and qualified. The Omnibus Executive Reform Amendment of 1992 changed this section to permit constitutional state officers to serve 2 consecutive terms. The amendment also specified that members of boards and commissions could be appointed or elected as may be prescribed by law along with the already included inferior state officers, and also empowered the General Assembly to condition those appointments with senatorial consent. During the last 40 years, pursuant to the authority granted it in this section, the General Assembly has significantly expanded the executive branch of government by establishing a number of appointed inferior officers. The Kentucky Court of Appeals held in 1942 that the clause in Section 93 stating that the duties and responsibilities of these officers shall be prescribed by law, language retained in the amended version of Section 92, empowered the General Assembly to authorize departments of state government to hire lawyers not affiliated with the Attorney General's office to represent the departments in legal proceedings and to act as their legal advisors, in Johnson v. Commonwealth. The court also held that a personnel director of the city of Louisville was not an inferior officer as described by Section 93, and therefore his term of office could be based on condition of good behavior and not limited to 4 years, in Kerr v. City of Louisville. 1937. The court ruled as invalid that part of a statute that set the term of some penitentiary commissioners for longer than 4 years, the commissioners being judged inferior officers within the scope of Section 93. In Commissioners of Sinking Fund v. George, 1898. Section 94. This section was repealed in 1992. Originally, it specified that the Register of Land Office be abolished.
Section 95. Time of election of elected constitutional state officers. The election under this Constitution for Governor, Lieutenant Governor, Treasurer, Auditor of Public Accounts, Attorney General, Secretary of State, and Commissioner of Agriculture, Labor and Statistics, shall be held on the first Tuesday after the first Monday in November, 1895, and the same day every 4 years thereafter. The Omnibus Executive Reform Amendment of 1992 deleted from this section the offices of Register of the Land Office and Superintendent of Public Instruction. There have been no published adjudications of this section. Section 96. Compensation of constitutional state officers. All officers mentioned in Section 95 shall be paid for their services by salary, and not otherwise. Section 96 is new to the Constitution. During the period of the Third Constitution, all of the officers mentioned in Section 95 in its original and amended forms were paid exclusively by salary except for the Attorney General, who was paid an annual salary of $500 plus 2% of all judgments rendered in fiscal courts in favor of the Commonwealth. In the opinion of the Attorney General, Section 96 did not prohibit the General Assembly from providing that the Commissioner of Agriculture should receive a daily fee for services on a state board, service on that board not being a duty of the Commissioner's office.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution by Robert M. Ireland, Oxford University Press.